Well-known rapper Young Thug, whose real name is Jeffrey Williams, became the center of one of the most controversial criminal trials in recent years. On May 9, 2022, Williams was indicted in Fulton County, Georgia, under the state's anti-racketeering law. A second, expanded indictment followed on August 8, 2022. Prosecutors claimed that Williams was the leader of a criminal street gang called YSL, short for Young Slime Life. According to the state, the group was not just a rap label. They argued it was actually a criminal organization connected to his music brand Young Stoner. Life. Williams was charged with racketeering conspiracy, participation in criminal street gang activity, and multiple gun and drug offenses. The case was scheduled to go before a jury. But during the trial in June 2024, something happened in the courtroom that shocked legal experts. On Friday, June 7, 2024, Fulton County Superior Court Chief Judge Ural Glanville was presiding over the trial. That day, one of the state's key witnesses refused to testify. Even after being granted immunity, the witness invoked the Fifth Amendment, refusing to answer questions that might incriminate him. Judge Glanville responded by holding the witness in contempt of court. He ordered the man to be jailed until Monday, June 10th, when the court would revisit whether he would agree to testify. Defense attorney Brian Steele, who represented Young Thug, stood up and placed the issue on the record. Steele began by explaining that he felt obligated to address the situation under the 6th and 14th Amendments of the U.S. Constitution. He told the court that he had recently learned something troubling. According to information he received, a meeting had taken place earlier that morning involving the judge, prosecutors, and the witness. But no members of the defense team were present. Steele explained that the defense had arrived at court hours earlier, but had no idea. Then the judge asked a direct question. "How did you find out about this?" Steele responded calmly, "I'm disturbed too." But the judge pressed him again. "How did you find out about it?" Instead of answering directly, Steele began explaining why the defense believed the meeting was legally problematic. He cited a Georgia Supreme Court case called Scuderi v. State, arguing that the defendants had a constitutional right to be present. The judge interrupted him again, insisted the question had not been answered. "How did you get this information?" Steele refused. "I'm not answering that question." The courtroom immediately became tense. He said it was deeply concerning that the defense somehow obtained information about private conversations inside the judge's chambers. Then he issued a warning. If Steele refused to reveal the source, the judge said he would hold him in contempt of court. Steele remained firm. He explained that revealing the source could violate attorney-client confidentiality, but the judge disagreed, insisted that simply explaining how the information was obtained did not fall under attorney-client privilege. Finally, Judge Glanville gave Steele an ultimatum. He ordered a 5-minute recess. When the court returned, Steele would have to reveal the source. If he didn't, he would be held in contempt of court. However, the rule also states that attorneys may disclose information if a court orders them to do so. So when the courtroom reconvened, Steele was facing an impossible situation. revealed the source, a risk being held in contempt. When proceedings resumed, Judge Glanville called Steele back to the podium. He asked the same question again. "How did you get this information?" Steele responded carefully, "I understand the court's concern, but under Georgia Rule of Professional Conduct 1.6, I cannot disclose that information." The judge paused, and he made his decision. "All right," he said, "I'm going to hold you in contempt." Steele would have until 5 p.m. to reconsider and reveal the source. But Steele still refused. He argued that even revealing who told him would violate his ethical duty as an attorney. Then he made a dramatic move. Steele asked the court for something even bigger. He requested a mistrial, and the moment he started explaining why, the judge interrupted him again. "From whom?" the judge demanded. Brian Steele tried to continue explaining the issue. "I'd like to get to the substance first." Judge Glanville cut him off. "Okay," the judge said firmly, "then you'll be in custody until you tell me how you got that information." The judge made it clear he wasn't asking what was said during the private meeting. Instead, he wanted to know who told Steele about it. "You've already given some details," the judge continued. "That tells me someone relayed the information to you." Steele immediately pushed back. "But you're assuming something," he replied, "because I already told you my position." Judge Glanville wasn't convinced. He began listing the only people who had been present in the chamber's meeting: the prosecutors, the witness's lawyer, court staff, deputies, the court reporter. "Unless someone in that room told you," the judge said. "There's only one other way you could have known." The implication was clear. Someone had leaked the information. Steele responded calmly. If someone did share that information, they might have violated privilege. But Steele quickly added something important. "I don't even know why that would be considered privileged communication in the first place." The judge disagreed. "Because that attorney represents a client," he replied. Steele looked confused. "Who are you talking about?" At that point, Judge Glanville ended the back and forth. "I'm not having any further conversation about this," he said. "Question still remains. Who gave you that information?" Steele tried to redirect the issue back to the real concern. He again asked the court to declare a mistrial. But the judge immediately denied the motion. Steele then said something that stunned the courtroom. "I understand that you spoke with a witness outside of our presence." The judge responded directly, "Yes, I had an ex parte conversation, and it was appropriate." Steele disagreed. "You influenced the witness," he said, "based on information and belief. And I want that on the record." The judge shrugged. If nothing improper happened, then that shouldn't be a problem. But Steele pressed further. "You're asking me to reveal a source," he said. "Why can't we address the real issue? Why this meeting happened without the defense present?" The judge's response was blunt. "Because you got information you shouldn't have had." Steele immediately asked the obvious question, "Why?" The judge simply replied, "That's for another day." Steele wasn't satisfied. "I didn't know about this until today," he explained, "and I raised the issue as soon as I learned about it." Then he cited a major Georgia Supreme Court case, according to Courtroom v. State, when a judge speaks with a witness outside the presence of the defendant during a critical stage of the trial, it can be grounds for automatic reversal. Judge Glanville pushed back. That's not the case if the conversation involved information the court was asked to hold privately. Steele disagreed again. You're not supposed to communicate with a sworn witness outside the presence of the defense. At this point, Steele formally requested a mistrial. A mistrial happens when a trial is terminated before reaching a verdict, because something occurs that makes a fair trial impossible. If granted, the case can be retried before a new jury. Steele argued that the private meeting violated the defendant's constitutional rights. In Courtroom v. State, the Georgia Supreme Court had ruled that defendants generally have the right to be present during all critical stages. However, that right can be waived if the defense agrees to it. But in the Young Thug case, the defense argued something different. The meeting was conducted secretly. Defendants were never told about it, and they were never given the opportunity to object. Steele then made another request. He asked the judge to release the transcript of the private meeting. That way we can understand exactly what happened, he said. And if anything occurred that wasn't recorded, we should know that too. Steele also explained the position he had been forced into. You've now put me in a position where revealing my source would violate Rule 1.6. That's the attorney confidentiality rule. But Judge Glanville rejected that argument. You can't hide behind Rule 1.6, the judge said. Steele responded immediately. I'm not hiding behind anything, the judge insisted. Someone must have leaked the information. That's the only way you could have gotten it, he said, unless you were eavesdropping. The judge then added something critical. Can't use information you had no business receiving and then claim privilege. Steele fired back. But that's exactly the issue, he said. We have a constitutional right to be present, and we are not waiving that right. At that point, the prosecutor, Edrin Love, stepped in. She told the court that the state did not know how the defense learned about the meeting. She also argued that the defense did not have the right to be present. According to the prosecution, the meeting was about civil contempt. However, the defense disagreed. Even if the contempt matter was technically civil, the meeting directly impacted the criminal trial. After hearing all arguments, Judge Glanville returned to the same question. He looked directly at Brian Steele. Last time, he said, "Who told you?" Steele refused again. This time, the judge followed through on his warning. Judge Glanville held him in criminal contempt and ordered deputies to take him into custody. "All right," the judge said. "Mr. Steele is in custody. Once he clears the area, we'll go ahead and get started," Steele protested. Removing him from the courtroom, he argued, would violate young Thug's right to counsel. Later that same day, however, Judge Glanville allowed Steele to return. Said he did not want to deprive the defendant of his chosen attorney. Instead, the judge issued an unusual punishment. Steele was sentenced to 20 days in jail, but he would only serve the time on weekends. Steele even asked to serve the sentence in the same facility where young Thug was being held. But before that, the case took another dramatic turn. Steele immediately appealed the contempt ruling. The Georgia Supreme Court issued an emergency order pausing the sentence. Months later, in October 2024, the court overturned the contempt ruling entirely. The justices concluded that Judge Glanville should have recused himself from the contempt matter because he was personally involved. The controversy didn't stop there. On July 15, 2024, another judge removed Judge Glanville from the case altogether. Eventually, on October 31, 2024, Jeffrey Williams reached a plea agreement. He pleaded guilty to several charges. His prison time was reduced to time already served, followed by 15 years of probation. This entire controversy highlights a major tension within the legal system. The appearance of fairness is just as important as fairness itself.